5 seconds to go. Start. In Ishwar Das Jain, it was suit for redemption of usufructuary mortgagee, which was dismissed by the High Court. The appellant before this court was the plaintiff. The defense of the respondent was that there was no relationship of mortgager and mortgagee between the parties, but that the relationship was as landlord and tenant. It was the defendant who has not produced his books of accounts to show that he was paying various amounts as rent to the appellant every month. In these circumstances, the extract of accounts produced by the respondent was found to be unbelievable and the suit decreed. In fact, the respondents in the written statement itself denied that they do not have the account books as they got damaged in rain and eaten by pests when they were kept on the roof of a building during the process of reconstruction. Such defense on the face of it appears to be made up defense. The account books were not produced by the respondents to discharge the onus on them. Therefore, the adverse inference had to be drawn against the respondents rather than against the appellant, who are not relying upon the entries in the account books alone to maintain suit, but reliance is on the invoices, debit note as well as ST1 form, which had been issued only after the receipt of goods. Though the respondents have denied the receipt of goods, but the receipt of goods is proved by numerous documents stamped and signed by the respondents. Section 42A5 of the Delhi Sales Tax Act 1975 excludes the sale made to the registered dealer from the taxable turnover, which reads thus: for the purposes of this act, taxable turnover means that part of a dealer's turnover during the prescribed period in any year which remains after deducting therefrom a goods of the class or classes specified in the certificate of registration of such dealer as being intended for use by him as raw materials in the manufacture in Delhi of any goods other than goods specified in the third schedule or newspapers for sale by him in the course of interstate trade or commerce, being a sale occasioning or effected by transfer of documents of title to such goods during the movement of such goods from Delhi, or for sale by him in the course of export outside India, being a sale occasioning the movement of such goods from Delhi, or a sale effected by transfer or documents of title to such goods effected during the movement of such goods from Delhi to place outside India and after the goods have crossed the customs frontiers of India. Rule 7 of the Delhi Sales Tax Rules 1975 allows the dealer to claim deduction from his turnover if he files a declaration in ST1 form duly filled in and signed by the purchasing dealer or a person authorized by him in writing. The said rule reads thus: conditions subject to which a dealer may claim deduction from his turnover on account of sales to registered dealers. A dealer who wishes to deduct from his turnover the amount in respect of sales on the ground that he is entitled to make such deduction under the provisions of subclause 5 of clause A of subsection 2 of section 4 shall produce copies of the relevant cash memos or bills according at the sales are cash sales or sales on credit, and a declaration in form ST1 duly filled in and signed by the purchasing dealer or a person authorized by him in writing. The respondents have admitted that no sales tax is payable by a dealer to a dealer. By necessary implication, the respondents are admitting the appellant to be a dealer as also the respondents to be dealer under the Delhi Sales Tax Act 1975. It is only on account of sales made by a dealer to a dealer that the sales tax is not be payable, as the incidence of payment of tax would be when the goods are sold to a consumer. The respondents as wholesaler were getting the benefit of trade discount, which is an agreed term of sale. Stop.